The main two hurdles I see for my DACA clients who want to apply for permanent residence, adjust status from within the United States, is one, they didn't enter with inspection, and two, they have an old removal order. I have a lot of clients who have DACA, Deferred Action for Childhood Arrivals, and who are now applying for permanent residence through marriage to a US citizen. And I know from my experience interacting with these clients how nerve-wracking your life must be right now dealing with the Trump administration and the risk of your whole life being taken away from you. I understand that's what you're going through. Let me start by saying, I think the chances of DACA actually being taken away as a protection during the next 3 years or whatever the 1,000 days remaining of this Trump administration are, very low. He tried to take it away, and a court basically determined that you DACA recipients have kind of a right, an expectation created some sort of procedural safeguards where it can't just be taken away from you. But as a result of that litigation, new DACA applicants are no longer being accepted. All you can do if you have DACA is renew your application or try to apply for permanent residence if you qualify, which many people don't. And that's what I'm going to talk about a little bit later. If you have DACA, the most important thing I can tell you is to timely renew your application, because if it expires and 1 year passes, you no longer have DACA and now you're fully deportable. By the way, the moment your DACA expires, if you don't have a timely application already pending, you might also be fully deportable. But once 1 year lapses after your DACA expires, you can no longer renew it. It'll be treated as an initial application, which will not get approved under current policies and court orders. The main two hurdles I see for my DACA clients who want to apply for permanent residence, adjust status from within the United States, is one, they didn't enter with inspection, and two, they have an old removal order. Either one of these could impact your ability to adjust status through marriage to a US citizen. You generally need to show that you entered legally, and by the way, if you have a removal order, I wouldn't even file anything right now, because if you show up to an interview, even with DACA, it's not guaranteed what's gonna happen. I've seen recently immigration officers tell people with DACA who've shown up to interviews, if it weren't for your DACA, ICE would be in here right now to detain you. So for now, the DACA status seems to be convincing USCIS officers to not get ICE involved, but it seems to be at the whim of the USCIS officer and whether or not the ICE quotas are met for that month or not. I mean, honestly, that seems to be what's happening because there's no rhyme or rhythm to the policies we're seeing. It's different in different offices at different times, and it's really difficult to make sense of it all. If you have DACA and you want to apply for adjustment of status through a family member, you're gonna need to meet 3 separate requirements. Well, at least there are 3 big hurdles that I've seen. One, you need a qualifying family relationship. And in most cases, that's gonna be either a US citizen spouse or a US citizen son or daughter who's over the age of 21. And this person would need to start by filing a family petition for you. If you entered legally with inspection, which means you have an I-94, a record of entry, or a visa you used to enter the US, or proof that you were paroled at some point after you entered the US, then you're good to go on that. But if you entered illegally, then adjustment of status in the US through marriage or through a US citizen son or daughter who's over 21 is probably not gonna work for you. That you would need to show lawful entry or parole to adjust status under those circumstances. So if you don't have those things, you might want to hold off for now. Or, this is beyond the scope of this video, if you had DACA continuously from before you were 18 years old and you never allowed it to lapse, that might mean you have no unlawful presence, which means we might be able to easily transfer your case to a consulate abroad so you can go for your interview and re-enter with a green card. Very fact specific. Most people have some unlawful presence, in which case this plan would not work that smoothly. Talk to an attorney before you file anything, because I have seen situations where DACA recipients aren't eligible for adjustment of status, but they could easily consular process without being forced to stay out of the US for more than a few weeks. And sometimes that's a good option. So talk to an attorney. It's case by case, and it's difficult to explain all of the rules and nuances in like a 10-minute YouTube video. The final barrier I see to a lot of DACA clients who are married to a US citizen is an old deportation order. So if you have an old removal order, you need to reopen it. I created several videos in the last few months specifically on reopening an old deportation order to fix it so that you could apply for adjustment of status. Generally speaking, if you didn't know about the hearing and that's why you never showed up and you got a removal order, it's generally easier to reopen. And I have successfully reopened several cases like that in just the past 6 months where we fixed an old deportation order, and now my clients are applying for permanent residence or some other immigration benefit. So those were happy stories, but in those instances, we need to show that you never received notice of the time or place of the hearing. And it can't just be my lawyer didn't tell me. If you had a lawyer, then it's pretty much going to be presumed that you had notice of the time or place, unless you're going to say your lawyer engaged in ineffective assistance of counsel and you're going to file a complaint against them. That's a different story. But generally speaking, those are the rules for reopening a hearing, a removal proceeding, if you never received a notice of it. Aside from that, you could ask the judge to just reopen a case due to exceptional circumstances. These are hard, depends on the judge, unlikely to succeed for most people, generally speaking. The final way to reopen a case, and this is going to apply to the majority of people who showed up to their hearing and got a deportation order, is going to be a joint motion to reopen where you and the Department of Homeland Security must jointly ask the judge to reopen the removal proceedings. The problem with this is that right now the Department of Homeland Security is not joining any motions. So if that is your best option, which, in recent consultations, I've told several people that they should do nothing, just keep your head down, because we can't do a joint motion to reopen until Trump leaves office. If that's your situation, you want to wait probably and tee up your case, get everything ready so that you're going to have a strong request for the Department of Homeland Security to join your motion to reopen. We have to prepare a package to send them showing you're a good person, you've been contributing to the community, you have no major criminal history, and if they agree to reopen this, you have a clear pathway to permanent residence, which oftentimes means filing the I-130 and getting the approval notice before we try to reopen the case. But right now, if you have a removal order, I would not file an I-130. Even if you have DACA, I think it's risky. I mean, the example I gave showed that the USCIS officer was not prepared to have ICE detain someone, and the only reason was because they had DACA, but I think it's risky to file an I-130 if you have a removal order now, even if you have DACA. I might be paranoid, but I think that policy will generally serve people well. In that instance, I would probably wait until Trump is gone, file an I-130 based on marriage or from your US citizen son or daughter who's over 21, wait till it's approved, then use the approval notice, show it to the Department of Homeland Security, and create a package of evidence to show you're a good person, you warrant a favorable exercise of discretion. And usually, under normal circumstances, which includes previous Republican and Democratic presidents, they will join that request. And then you submit it to the judge reopens the case, you show the judge that my client is clearly eligible for permanent residence. Generally speaking, the judge will terminate the removal proceedings, and now you no longer have a removal order, and we can apply for your green card with USCIS if you meet all the other requirements. All right, guys, that brings us to the end of today's video. If you have DACA and you have questions about how to proceed, you might qualify for an immigration benefit, but you want to know the risks and the possible benefits, the first step would be to schedule a consultation directly with me. The link to schedule a consultation is in the video description below. You could also go to my website, darianlaw.com, or call my office and speak with someone who could help you schedule. If you're new to my channel, be sure to subscribe because I put out 5 videos a week discussing changes and nuances I've seen in the immigration law under Trump's policies and the Stephen Miller administration. So if you want to stay up to date with everything, be sure to subscribe, and I'll see you guys next time for another video.